Universiteit Ragnar.
Just look at the first attempt to your surname. Just tell me if the first attempt is correct and if not, just check.
The first attempt was 100% correct. The one that was scratched out.
Thank you. Please proceed.
Thank you. Your Worship, I firstly thank the court for the indulgence until today. As indicated yesterday, we have compiled a comprehensive answer to the allegations and aversions made by the applicant in her sworn affidavit, and I wish to hand in the closing documents affidavit by the investigating officer, as well as a number of annexures as Exhibit C.
Thank you.
That is also the case for the state.
Received and not. Did you supply a copy of this to the defense?
I did, Your Worship. Thank you.
I note that your affidavit basically consists of 24 pages.
That is correct.
It's in the interest of the members of the public that we actually make them aware of the content of this affidavit.
Yes, it is quite voluminous, I think nearly 200 pages, but I have instructed my PA to make more copies, and I can maybe just provide one for the press, so that they can also peruse what is stated here.
What I recommend that we do is just briefly deal with your affidavit. Highlight the most important aspects of your affidavit. So you don't really have to read it out word for word, but please just highlight the most important aspects in this affidavit and make one available to the media.
Yes, I hear what Your Worship says. The problem is that, as indicated, we actually have to answer to each and every allegation or averment that the applicant made. So it should be seen holistically. It's very difficult for me to point out certain aspects that's more or less important, as we are of the view that everything, especially in conjunction with all those annexures. But for purposes of this exercise, I don't think it's necessary to read everything. If the court wants, I shall read it into the report.
Yes, I think it is important, even if it's going to take time,
As it is.
that you proceed and place it on paper properly so that everybody is informed.
Yes.
Yes.
Affidavit, as I indicated, by Benjamin Friedemann College. I'm a captain in the South African Police Service with personnel number 0431-262-7, attached to the Serious Corruption Investigation Unit, SCI, Directorate for Priority Crime Investigation, employed at the Absa Building, Charlotte Mopeke Street, CBD, Bloemfontein, Free State. I'm the investigating officer in the matter of State versus Mackenzie and others, set down for trial in the Free State High Court, Bloemfontein, commencing 15 April 2025, in which Ms. Shilota, accused number 17, is indicted and charged with the offences as set out in the J15 handed up in these proceedings. Read with the Deputy Secretary of State's extradition warrant stroke order dated 31 July 2024. Save where indicated otherwise by the context thereof, the facts and allegations herein contained are within my personal knowledge. They are also true and correct. Shilota faces charges comprising 4 counts of fraud, resulting in a loss to the state in an amount of excess of 86.5 million rand. Then 5 counts of corruption in terms of Section 3 of PRECA, Prevention of Corrupt Activities Act, in the amounts of 53,550, 470,000, 200,000, and 100,000, 30,000, and 250,000, together with the alternative charge. Relating to the asbestos project procurement, which was facilitated by the Free State Department of Human Settlements over the period 2014 to 2017. It is further alleged that Ms. Shilota acted in common purpose or being part of a conspiracy to commit the aforesaid crimes together with certain of her co-accused. These offences fall within the ambit of Schedule 5 to the Criminal Procedure Act, the CPA, and accordingly Ms. Shilota bears the onus to establish, on a balance of probabilities, that the interests of justice permit the release on bail. In this regard, Section 60, subsection 4 of the CPA provides that the interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. I'm going to refer, Your Worship, with permission of the court, to the relevant section, which is B, where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Paragraph 6, the state opposes bail on grounds set out in section 64B of the CPA and contends that Ms. Shilota is a flight risk and likely to evade trial. 7, I have read the founding affidavit of the applicant, Ms. Moraori Selina Shilota, dated 12 August 2024, in which she applies for bail and submits that she has adduced evidence which serves to convince this court that it is in the interest of justice for her to be released on bail. This is denied by the state. I set out at the outset of this affidavit that Ms. Shilota has omitted to bring to this court's attention in her bail application numerous material facts which militate against the granting of bail and serve to establish a past pattern of conduct which is consistent with someone likely to evade trial. She has further misled the court in her affidavit and or misrepresented her personal facts and her likelihood of being a flight risk, which aspects will be covered in the responding ad seriatim section. These factors it is submitted show that Ms. Shilota has no intention of standing, there is just a slight mistake, intention of standing trial in South Africa. Then paragraph 9, the omitted facts, Ms. Shilota had to be extradited from the United States of America in order to stand trial. This process began in February 2022. Paragraph 10, Ms. Shilota had, to the best of my knowledge and belief, been studying at Bay Atlantic University on a study visa. However, such visa expired in November 2023. Ms. Shilota had been the subject of an Interpol red notice issued after application was made in October 2021 and issued on 13 December 2021. Ms. Shilota can, at best, have last left the United States nearly 3 years ago, as she was unable to travel internationally due to the existence of the red notice, as she would have been arrested upon entering the United States again. 12. 12, initially Ms. Shilota was studying in the United States of America at Bay Atlantic University in Washington, D.C. through a bursary awarded to her by the Free State Provincial Government, the Director General Office of the Premier, on the 18th of December 2019 for studies in the 2020 academic year. 13, on or about 16 August 2022, Mr. Raleigh Konsani, Director General in the Office of the Premier of the Free State Provincial Government, gave notice to Ms. Shilota of the possible termination of her bursary on the grounds of the arrest warrant issued for her in South Africa in relation to the asbestos matter and the extradition request lodged with the relevant authorities in the United States. Mr. Raleigh Konsani alleges in his correspondence that she breached the terms of a bursary agreement by failing to cooperate with the South African law enforcement authorities. For these reasons, he afforded her an opportunity to provide representations as to why her bursary should not be terminated and payment stopped. A copy of this notice is attached, marked AA1. 14, on an unknown date, Ms. Shilota replied to this notice setting out the reasons why a bursary should not be cancelled. Of relevance, she alleged that she had never been instructed to do anything by the Hawks since we interviewed her, and that she provided the FBI with all the information they needed from her. Neither of these assertions are correct, as Ms. Shilota had undertaken to provide a statement to me by the 23rd of October 2021, but has to date failed to do so. A copy of her representations is attached, marked AA2. 15, on or about 19 September 2022, Mr. Raleigh Konsani requested Ms. Shilota to report to his office within 10 days in order to meet and resolve the impasse, failing which her bursary would be revoked with immediate effect. A copy of this correspondence is attached, marked AA3. 16. Ms. Shilota did not attend such meeting within the time period afforded to her to do so or at all. And accordingly, on the 6th of October 2022, she was notified that her bursary had been terminated and that no further payments would be made, save for a flight ticket for Ms. Shilota's return to South Africa, to be covered in the event she wished to return. A copy of this correspondence is attached, marked AA4. Ms. Shilota did not return. 17. A former legal counsel had communicated to the Free State High Court on 20 January 2023 in open court during a pre-trial proceeding that Ms. Shilota would voluntarily return to the country to face trial. By 3 May 2023, the former attorney Victor Nkasu advised the prosecutor, Advocate Nason, that he had not received any instructions from Ms. Shilota or her family pursuant to that undertaking made in January 2023 as to a voluntarily return to South Africa. A copy of the email correspondence recording the aforesaid is attached, marked AA5. 18. I'm aware that in February 2023, Ms. Shilota was arrested and detained in the United States by their immigration agency known as ICE. I do not know all of the circumstances pertaining to her arrest, but understand that it had regard to her student visa having expired. Ms. Shilota was released from custody in the United States, and I do not believe any immigration-related charges were pursued against her at that time. When this allegation was raised in my answering affidavit in the Constitutional Court proceedings, Ms. Shilota did not deny them. She instead stated under oath in response, in a replying affidavit to that paragraph, that, I quote, the allegations contained in this paragraph are wholly irrelevant to the present application that is before this Honourable Court, and request that they be disregarded in their entirety. 19. The extradition proceedings in the United States were approved by the United States Department of Justice and commenced in April 2024. This delay was occasioned because Ms. Shilota's location in the United States became unknown to the U.S. Marshal Service. In this regard, I attached email correspondence between the prosecutor, Advocate Nason, and Ms. Maria Lerner from the U.S. Department of Justice, dated 4 and 14 March, which demonstrates that a second location for her in Baltimore had been identified and surveillance was underway. A copy of the email correspondence in this regard is attached, marked AA6. 20. The United States District Court for the District of Maryland was ultimately seized with the extradition hearing of Ms. Shilota once she had been arrested on the 12th of April 2024. I attached, marked 8A7, a copy of a motion to proceed with the extradition hearing document dated 21 May 2024, which was prepared by the United States Attorney, which sets out inter alia that 20.1. Ms. Shilota initially indicated an intention to contest detention, i.e. to apply for bail. The US government briefed the issue, but when it came time to argue the matter, Ms. Shilota abandoned this objection and consented to detention. 20.2, the US government filed a memorandum of law in order to comply with Ms. Shilota's request to have a briefing scheduled in advance of the extradition hearing. Your Worship, just for the record, the Americans call it a briefing, which is actually an application, but that's how they word it. No response ended up being filed by Ms. Shilota. 20.3, on the day the hearing was to take place, being the 9th of May 2024, Ms. Shilota asked for a continuance in order to pursue proceedings in South Africa to have the extradition request quashed in this country on the grounds the prosecution was politically motivated. This continuance was granted on a limited basis despite the US government's objection. 20.4. On the 7th of June 2024, the United States District Court for the District of Maryland found Ms. Shilota to be extraditable. Ms. Shilota apparently conceded in those proceedings that she had no arguments to raise. I do not have a copy of the court order to this effect, but attach a copy of an email received from Ms. Lerner informing the state of the outcome of the hearing, a copy of which is attached, marked AA8. 21. As is apparent from Ms. Lerner's email above, Ms. Shilota intended to approach the Secretary of State for an appeal. She did proceed to note an appeal, a copy of which is not in my possession, but the said appeal with the Secretary of State failed, and on the 31st of July 2024, her extradition was approved per the document handed up to court as Exhibit A. 22. Accordingly, Ms. Shilota's complaint that she has been in custody for nearly 4 months is due to her own making in taking all manner of steps to delay the extradition proceedings. 23. Around the same time, Ms. Shilota approached the Constitutional Court in South Africa on an urgent basis and by means of direct access in order to seek an order that the decision to apply for extradition and the arrest warrant itself be set aside on nebulous grounds, making assertions that are unsubstantiated, inconsistent with the truth, and defamatory of myself and then Brigadier now Major General Nico Gerber, who interviewed her. Despite accusing us of apartheid-era style tactics and of abusing her constitutional rights, similar allegations being made in this bail application, the Constitutional Court, having considered my answering affidavit, responding to such allegations and setting out the true course of events occurring when she was interviewed in the United States in September 2021, dismissed this application on the 26th of July 2024 per the court order attached mark AA9. 24. Importantly, in these proceedings, Ms. Shilota alleged that the prosecutor, Advocate Nyssen, was one of the two members of the team which interviewed and questioned her in the United States. This is completely untrue, as Advocate Nyssen never traveled to America and never questioned Ms. Shilota. 25. I have not attached all the papers filed in the Constitutional Court proceedings. This is so as to avoid prolixity. I do, however, attach copies of Ms. Shilota's founding affidavit and my answering affidavit, excluding amateur. These are marked AA 10.1 and AA 10.2 respectively. The full papers can be made available to this court should it wish to have regard to same. 26. A temporary passport had to be arranged for Ms. Shilota for a return to South Africa, given that her passport was left at her residence according to her. She was brought back to the country under police guard on the 8th of August 2024. Ad seriatim response. At paragraph 1, these allegations are admitted. Paragraph 2, save for pointing out that Ms. Shilota cannot be charged by the state on the money laundering charges, as the U.S. Department of State refused to indict her on these allegations are admitted. At paragraph 3 and 4, it is denied that all the evidence Ms. Shilota has placed before this court shows that it is in the interest of justice that she be released on bail, and that she is not a flight risk. It is disputed that Ms. Shilota has discharged the onus placed on her by the CPA in this regard. Paragraph 5, these allegations are denied. This is a strange statement for Ms. Shilota to make, considering she has not even requested access to the docket, which demonstrates the evidence the state has against her. By way of an FTI memorandum, attached here to marked AA11, a copy of which was sent to the United States authorities in support of the extradition request, the forensic investigators appointed by the state in this matter have summarized the evidence against Ms. Shilota. May I just add on here, it is only a summary. It's an extract from a much larger forensic report, Your Worship. I submit that the evidence is overwhelming and was considered favorably by the U.S. authorities when granting Ms. Shilota's extradition. Paragraph 6 to 9, I deny that all the facts contained in the affidavit are true and correct, and that the release on bail is in the interest of justice. Save for the aforesaid denial, the allegations contained herein are noted. Paragraph 10. It is denied that Ms. Shilota has resided in the Free State for her entire life, from 2020 and until her extradition on the 8th of August 2024. Ms. Shilota has been residing in the United States of America. Paragraph 11. It is denied that Ms. Shilota enjoys a close family relationship with her step-parents, her half-sister and extended family members. Ms. Shilota has not visited South Africa since 2020 to visit such persons, neither has her son. She does not state with whom she resided at Bloemfontein property, or why she does not intend returning to reside at that property if she is granted bail. Paragraph 12. Annexure NC1 was not attached to the copies of the affidavits presented to the state, but it is admitted that Ms. Shilota owns the aforesaid property. Just for the record, the instructing attorney did forward last night sometime a copy of NC1. 14. Ms. Shilota has not stated who It is that currently resides there and whether or not she receives any rental income from such property. 13. These allegations are denied. In a founding affidavit filed in the Constitutional Court, Ms. Shilota testifies at paragraph 33 that she, quote, settled into her surrounding community in Baltimore, Maryland. Further, quote, I have made friends, acquaintances, and have even obtained a driver's license. When I interviewed Ms. Shilota in Baltimore on the 22nd of September 2021, she indicated that her boyfriend, whose name I cannot recall, would come to check in on her during the course of the interview, and a gentleman did indeed visit her. Whereafter the interview was paused, and Ms. Shilota spoke to him in private. Of course, I do not know the whereabouts of such person since September 2021, or Ms. Shilota's relationship status, but I believe that her boyfriend, as at that time, was residing in the United States and was not the father of her son. Paragraph 40. It is admitted that Ms. Shilota has no current passport in her possession and was transported back to South Africa on emergency travel documents. Nothing, however, prevents Ms. Shilota from applying for a new passport or for a reissue of the passport she left behind in the United States, which I am informed bears passport number A 08543858, was issued on the 28th of May 2019 and expires only in 2029. Paragraph 15. Save for reiterating that Ms. Shilota was extradited on the 8th of August 2024 and has remained in police custody since such time and has not resided outside of such custody, these allegations are admitted. Paragraph 16. These allegations are admitted. It is unknown how Ms. Shilota has managed to fund her living expenses and study expenses while in the United States. As pointed out above, her bursary was cancelled in 2022 already. Logical questions should further be asked as to who is funding her legal representation, both in these proceedings as well as those dismissed proceedings in the Constitutional Court, especially in the light of the fact that she can only afford bail of 2,500 rand. Paragraph 17. While I note these allegations, I dispute that it is Ms. Shilota's intention to have her son return to South Africa. I dispute this because she gives no indication as to 1. When his return is expected and who will be paying for his travel. 2. How he would reintegrate into his family life upon his return, considering he's been living in Nigeria and away from his mother since 2020. 3. Which school he will attend. 4. How she will fund his education and living expenses given the unemployment. Paragraph 8. It is admitted that Ms. Shilota has no criminal record in South Africa nor any other pending charges. I also know of no pending cases against her. I reiterate, however, that I understand that there were immigration-related criminal issues pursued against her in the United States at some time, but I have no further information in that regard. The fact remains that Ms. Shilota continued to reside in the United States after her study visa had expired in November 2023. Paragraphs 19 and 19.1, these allegations are denied. The charges Ms. Shilota faces emanate from a comprehensive investigation, and it is admitted that there is a strong case against her. Paragraph 19.2. These allegations are not materially disputed, save for some important clarifications and corrections which I shall set out here. 1. Ms. Shilota was considered to be a state witness. In this regard, I attach marked AA12, email correspondence between her and Brigadier Gerber in this regard. 2. It is correct that Ms. Shilota was not charged in this matter until October 2021. This was because she had been cooperating with the state until such time, not because we had no evidence against her. 3. Mashilota was informed at the commencement of my interview with her in the United States on the 22nd and 23rd of September 2021 that I had now also had access to her computer and email accounts and had questions based on those documents as well as what had been canvassed at the State Capture Commission of Inquiry. 4. Mashilota was informed during my interview, which she attended voluntarily, that she was being questioned as a witness for the state. However, the questions asked of Mashilota were seldomly answered fully and completely, and she often questioned their relevance. All her answers were measured and careful, and it was evident that she had been taken off guard by the interview. Mashilota was not very cooperative and had shown irritation and frustration at many of her questions, especially when she was pushed for more details or further answers. Accordingly, we did inform her during our questioning on the 22nd of September 2021 that Mashilota should think about the matter overnight, as a failure to cooperate may lead to us considering her to be a suspect. This was not a threat, but a fair warning. 5. It is my impression that Mashilota did not cooperate with us during our questioning. I have no documentary evidence to support this view because I did not take a warning statement from Mashilota until the end of the interviews on the 23rd of September 2021, when she ceased cooperation. There would have been no need for me to take such a statement as Mashilota answered the questions posed of her fully and completely. 6. It is denied that there is no factual and objective evidence against Mashilota. I have referred above to the FDI memorandum, which outlines this evidence. Mashilota's own emails and records reflect much of the evidence the state has against her. I have no knowledge of the extent of other entities' investigations, and none of them were leading towards criminal investigation in any event. My investigation has found sufficient evidence to sustain charges. 19.3. These allegations are noted. Paragraph 20. These allegations are denied. Mashilota has fought extradition at every step, and by every means she has no desire to stand trial and prove her innocence, as she says. In relation to the alleged unconstitutionality of her arrest and charges, this is denied. The Constitutional Court and the United States Courts and the Deputy Secretary of State have found the case against her and the state's conduct to date pertaining to her arrest to be unobjectionable. 21 and 22, these allegations are denied. Mashilota ceased cooperating with the investigative team as a state witness in September 2021. Mashilota has repeatedly accused me and the investigative team of underhanded, unconstitutional and apartheid-era style tactics. Mashilota has also, through her legal representative, misled the court and the prosecution team about her willingness to return to South Africa voluntarily. This is evidence of someone who has very little respect for the South African legal system. Mashilota need not possess travel documents to evade trial. She has previously proved to have evaded authorities in the United States. There is nothing to say she will not disappear within the borders of South Africa too. Paragraph 23, the allegations are noted. 24 and 25. Sorry for correcting the position that Mashilota was in detention, quote, imprisoned and detained in jail, in the true sense of the words, in the United States from the 12th of April to the 8th of August 2024, these allegations are admitted. Michelota was being held in a detention facility in the United States during this period, and she abandoned her attempt to apply for bail. 26. The state did not oppose bail for any of Michelota's co-accused, as they were not regarded as flight risks. They were resident in South Africa and did not have to be extradited, nor did they oppose any legal proceedings to avoid being arrested and charged. 27. These allegations are denied. Each accused person's bail application is judged on its own merits. The onus Michelota has to discharge would of necessity be discharged through facts individual to her and not available or relevant to her co-accused. 28. While these allegations are admitted, the case law surrounding bail is well established and Michelota's rights are protected by the relevant provisions of the CPA and will be taken cognizance of by this court through the exercise of its jurisdiction, or rather discretion. 29. While the state was informed that Michelota would pursue a bail application, the precise grounds upon which Michelota would pursue a bail application only became known to the state on the morning of the 12th of August 2024, when an affidavit was presented to it. 30. These allegations are admitted. 31. These allegations are denied. In any event, Michelota may still evade trial if she does not obtain travel documents until the criminal proceedings are completed. 32. These allegations are noted. The state does not oppose the application for release on these grounds, save to state that it is the state's case that Michelota is likely to evade trial and should not be released on bail for this reason. 33 and 34. These allegations are denied. I've set out about the long history of Michelota having failed to cooperate with law enforcement agencies and requests made by the state and the SABC representatives, and further was changing her stance before the US courts and evading US authorities. 35. In the event this court decides to grant bail to Michelota, it is admitted that this amount is far too low and inconsistent with the nature and extent of the charges against Michelota. The other accused were granted bail in the amounts of between 50,000 and 200,000 each. Argument as to the appropriate amount will be addressed if needs be by the prosecution legal team. 36. These allegations are noted. Again, the sources of Michelota's available funds are undisclosed and questionable. 37. These allegations are denied. Michelota has not visited South Africa in over 4 years. Whatever ties she may have had to the country and province have surely weakened over this time. 38 and 39, these allegations are denied, as well as 40 and 41. Thank you.
So the application was then closed by the state, and this is now formally as it's
Thank you, Your Worship. Your Worship, one has to really question what the intention is here from the state. Is it to oppose bail, or is it to create an entirely new narrative regarding Michelota's arrest, regarding Michelota's charges, and to have an entirely new extradition hearing here in South Africa? The entirety of their opposition on bail is based on extradition proceedings that already took place and were concluded in the United States. In order to properly place the actual facts before this court of that extradition, I do wish to meticulously take your worship through the exact points of how that transpired and why. I shall be slightly long-winded, your worship, but due to the fact that the state has given us this mammoth of an opposition to bail, much of which is a repetition of their extradition request and a repetition of their answer in the Constitutional Court, none of which ought to bear reference in a bail hearing. Your worship, S versus Viljoen is a case where the Supreme Court of Appeal cautioned against the state or any other party holding a dress rehearsal for a hearing. This is not criminal proceedings. This is a judicial process. The case law is clear on that. However, the state has tried, and it has tried valiantly, we will give them that, to paint a picture of this accused as going above and beyond to evade trial, evade arrest. And so while we did not anticipate that the state would go to such desperate lengths to paint her in this way, we have to respond first to the extradition, then to the Constitutional Court issue, and then to bring it back to why we're here. We're here for a bail application, your worship. So let's start.
Before you continue with that, this is now your reply.
Yes.
To the state's act.
Yes.
I'm going to ask you to do it in writing, because it's also going to be quite a lengthy process.
Yes.
And I want you to get your mind together and to put it on paper so that I also have it to study it.
Indeed.
When I prepare my judgment.
That was going to, thank you so much, your worship. I'm sorry for having disturbed you there for a second in the completion of your thought, your worship. That was going to be the submission at the very end of our oral response to the state's case, that we will be reducing every single thing that we have adduced in oral argument to writing. Owing to the fact that we have been dealing with the state for quite some time, it is easy for us to stand up and respond to the state's case because, as we said yesterday and anticipated, there was nothing new that they were going to bring. And indeed, as we're saying, it is a repetition of their extradition case, and it is a repetition of the Constitutional Court arguments. And so I wish to start first by quoting
I'm going to ask you to put it in writing.
Your worship, if we could please, because I think it is very important. The state has created a very unfortunate narrative here. There isn't any other person other than your worship that will have regard to our oral responses to the state's case. And so while I will not be taking longer than 35 minutes, I do wish to make certain points very just clear on oral argument, and then those will be fleshed out in a response to the state's case for your worship's convenience. And we will not make anything, no points beyond the ones that we're going to make today, right now. We simply do wish to have those oral arguments set out in response in these proceedings. If your worship would please grant me the...
Unfortunately, I'm not going to grant that. I'm going to ask you to respond in writing so that I don't miss out on anything when I consider this application. It is important that I have everything with me, and it's going to be a lengthy process, so let us stick to the papers and do it on paper so that I can look at it carefully and consider it.
And
So I'm not going to allow you to continue addressing me on this. We will just waste a lot of time because you're going to repeat it on paper.
I see, your worship.
So all I need to know from you now is your availability.
I see.
When will it be ready? Tomorrow?
On Thursday.
Thursday.
On Thursday. Could I please request direction with what happens after we have filed our response?
After you file the response,
Yes.
obviously then it will be arguments and then the judgment.
Indeed. And will arguments be happening that day?
Also in writing.
will arguments be happening in writing?
So you can also just start preparing that if you wish, and the state can also start preparing that unless they still need to first listen to your reply before they proceed with their written arguments.
Yes. Your Worship, could I please just get an understanding as to why, other than Your Worship needing to have the arguments in writing and understandably not wishing to miss anything, why it is that we would be barred from making any further oral arguments in this matter when we are told we're going to be wasting time, when yesterday the impression was given that the entire reason for the matter being stood down to today was to afford everyone the opportunity to make all the arguments that they could on behalf of their clients so that this bail application could be heard to finality. And so now at 10 o'clock in the morning, when we have the entire day still left, we are told we cannot or we are not able to make these oral submissions. Could there be a reason for that? Because we do strongly feel that it is very necessary to make these oral submissions, and it will do nothing for us to stay overnight and draft the written submissions for Your Worship's convenience when there are real concrete issues that need to be canvassed orally by us in defense of our clients' rights. Is this not perhaps prejudicial to our client's right to have her bail application heard to finality and for us to bring this case to Your Worship? I understand that Your Worship does need to have those in writing, but if that will happen on Thursday, what is the problem with us stating our case to finality orally before Your Worship when we have the court's time?
I've already said I'm not going to have it be repeated in writing and oral. So I've already decided and I've already told you what my decision is based on. And I'm not going to deviate from that. So we will postpone it until Thursday on your request to be ready with us. If you want to save time on Thursday, be prepared for the rest of it as well. I am here the whole day, but I won't be here tomorrow.
You're here the whole day on Thursday,
I'm here every day.
but not the whole day today.
No, yeah, today as well. If you're ready by this afternoon, I'm ready.
To present oral arguments or simply written?
No, written.
Simply written. All right. That is then the finalization of our oral statements. We will be submitting that to Your Worship as requested, but we do note that this is in direct violation of our client's right to have her case heard and also for her bail application to be heard in terms of the Criminal Procedure Act and the Constitution. It baffles the mind as to why this would be the correct course of action, but we are indebted to Your Worship for this guidance, however confusing it may be. Thank you.
Thank you. It's noted. Can I just hear from the state your availability?
I am available Thursday.
That will be the 15th of August.
Indeed. Your Worship, thank you.
And also to be detained again at Bloemfontein, or will she release?
Please, Bloemfontein, as requested by the police.
Can I just hear from the defense? Bloemfontein, any objection?
Well, we have objection to every single process after we've been barred from speaking, Your Worship. So if she goes to Bloemfontein, she goes to Bloemfontein. There's nothing else we can say. We were here to apply for bail. So any further detention is objected to by us. But if it must be Bloemfontein, it is Bloemfontein.
Thank you. Postponed then until 15 August for the defense replying affidavits. In custody at Bloemfontein.
Ready, Surah, thank you.
Council process.
All rise. Please kindly stop recording the issues 5 and 13. We're done.